Okay, there were just a couple of insanity legal defenses that I wanted to cover before going on to juvenile justice. Um, the first one is entrapment. This occurs when the government induces a person to commit a crime and then tries to punish the person for committing it. If a judge or jury believes that a suspect was predisposed to commit the crime anyway, then the suspect may be found guilty, even if the government did help the defendant commit the crime. This can be a sticky wicket and one that's best left to judges and juries. The last defense The last defense we'll cover is necessity. Defendants using this defense must show that their conduct was necessary in order to prevent some greater harm, and when that conduct was not excused under some other law, such as self-defense. This defense is used when someone is engaged in socially useful functions that can intentionally cause injury or loss or damage. For example, fire services have to destroy property in order to keep fires from spreading. Parents who steal in order to feed their children are not, however, covered by this defense. Generally, the defendant must show, one, the harm he sought to avoid outweighs danger of the prohibited conduct he's charged with, and two, he had no reasonable alternative, and three, he ceased to engage in the prohibited conduct as soon as the danger passed. He did not himself create the danger he sought to avoid. So a drunk driver's contention that he drove his car to get away from a kidnapper would not be accepted if he drove the car beyond what was necessary to get away from the kidnappers. One famous case was the United States v. Shun in 1992. 30 people protesting against giving American tax dollars out of El Salvador broke into an IRS office in Tucson, where they splashed fake blood on counters, walls, and carpeting, and generally obstructed the office's operation. The court ruled that the elements of necessity did not exist in this crime. Why? Well, there were other ways of protesting, for example. Okay, moving on to juvenile justice. Primarily, diversion programs are set up for juveniles. Many illegal behaviors by juveniles are handled informally by neighbors, business owners, teachers, and others. But when informal resolutions fail, the children are sent to formal juvenile justice system. Historically, before the 16th century, the young were viewed as either property or as miniature adults who were expected to assume the same responsibilities and therefore could be sanctioned the same as adults. These attitudes changed in the 16th and 17th century when children began to be viewed as corruptible but worthy of correction. The new view was that children could change and their behavior could become pro-social. These were ideas the colonists brought to America. The juvenile justice system in America began with apprenticeship, where middle and upper class children who were hard to handle were taught a skilled trade by a master. Another closely related system was the binding out system, where children were bound over to a master craftsman for care. However, this system didn't require teaching the child a trade and was used more by lower class families. The first correctional institution for youths in the United States were houses of refuge, which were designed to be institutions where children could be reformed and turned into hard-working members of the community. Children could be committed by a constable, a parent, or by order of an alderman. When houses of refuge were not successful, children could then be placed on farms in the Midwest and West to remove them from supposedly corrupting influences of their parents and the cities. John Augustus, the father of probation, provided bail and supervision for children as well. After his death, his probation programs were carried on by the Boston Children's Aid Society. In the late 1800s, houses of refuge were failing and the number of problem youths was increasing, so one response was to establish reform schools, industrial schools, and training schools. Formal education was the aim of these schools. Training schools are still used today, although more emphasis is placed on treatment, but the ideas of custody and control are still in effect. In addition, at this time, another group of reformers began to advocate for juvenile courts. They felt that criminal courts failed to respond adequately to the problems of the young people. The first court designed specifically to deal with children was in Chicago in 1870, and it led the way to the development of a separate juvenile system nationwide. The idea was to separate juvenile system rests on the premise that children are developmentally different from adults and are more amenable to treatment and rehabilitation. In their beginnings, juvenile courts were informal and complaints could be made by almost anyone. Hearings were held in offices which were closed to the public. Few records were kept. There was little concern for due process, which allowed for sanctions without proof of guilt. Judges had wide discretion, ranging from giving a warning to placing children in institutions. In 1870, the Illinois Supreme Court held that due process protections were necessary, but instead of establishing due process protections, Illinois passed the Juvenile Court Act, which created the first juvenile court. A special judge oversaw these courts. Hearings were held in a separate courtroom and separate records were kept of these proceedings. It wasn't until 1967 that the Supreme Court ruled that juveniles should be accorded the same due process rights as adults. The original case was in Arizona. Gerald Galt, 15 years old at the time, was taken into custody because a neighbor had reported that he had made a lewd phone call to her. Galt said that his friend had made the call while Galt was getting ready for work. Galt was placed in the county children's detention home and was not allowed to return home to his mother. In a preliminary trial, the judge said he would think about the case. Later, the family was notified of a hearing date and Galt was sentenced to the state industrial school until he turned 21. If he had been an adult, he would have been sentenced to 2 months with a fine of $5 to $50. Galt had not been told of the charges. He was not allowed witnesses, nor was he allowed to confront his accuser. The case eventually went to the Supreme Court. Slide 15, or the next slide, is a result of the Galt case. Juveniles now have the right against self-incrimination, the right to adequate notice of charges, the right to conduct and cross-examine the accuser, the right to assistance of counsel, and the right to sworn testimony and appeal. After Galt, the standard of proof typically employed at the adjudication stage was a preponderance of evidence. In 1970, I think this information was on a previous slide. In 1970, in re Winship, the Supreme Court held that charges must be proven beyond a reasonable doubt. Galt and Winship not only increased procedural formality, but also shifted the focus from the child to the Child's Act, which was a short step to offense-based sentencing and a punitive orientation. A year later, in McKeever v. Pennsylvania, the court held that juveniles were not entitled to a trial by jury. Roper v. Simmons in 2005, the court found that the 8th and 14th Amendment prohibit execution of offenders who were under 18 at the time of the crime. Currently, the police are the primary gatekeepers to the formal justice system process. The trend is moving toward referring more youths to juvenile court. Fewer cases are handled within police departments, and more cases are referred to criminal courts. Juveniles can be charged with 2 types of crimes. One is status offenses. these offenses are actions that, if they were committed by an adult, would not be a crime, such as truancy or running away from home. The second type of crime is one that's the same as those for adult offenders. More recent development to the juvenile court diversion, a more recent development in juvenile court are diversion programs in teen court. Teen courts or youth courts are a relatively new way of dealing with young first-time offenders. Teen courts are based on 4 different models. An adult judge and the other courtroom actors are teens, a youth judge in addition to the other teens, or a tribunal of teens or peer jury. Most teen courts do not determine guilt or innocence. Rather, they determine diversion alternatives, such as community service or restitution. As of 2005, there were 1,035 teen courts that processed 100,000 cases a year. There hasn't been much empirical research, and what has been done finds mixed evidence of effectiveness. When a juvenile is tried in formal juvenile court, things work a little differently than adult court. First of all, juvenile court has its own terminology. Okay. Juveniles can be transferred to adult court under the following conditions: probable cause, the youth presents a threat to the community, existing treatment programs would not be appropriate, or programs within the adult system would be more appropriate. These conditions can vary from jurisdiction to jurisdiction, but there can be a judicial waiver where the judge transfers a juvenile to adult court. The limitations on juvenile waiver have been broadened to allow juvenile court judges to transfer younger juveniles and those charged with less serious offenses. Prosecutors now have more authority to file certain juvenile cases in either juvenile court or criminal court as they choose. Most states have provisions that require a juvenile who's been prosecuted in criminal court to be prosecuted in criminal court for all subsequent cases. In rare cases, a juvenile will violate a federal law, usually having to do with drugs or prostitution. In order for this to occur, the Attorney General has to certify that the case involves important federal interests and that the crime is a crime of violence. If the feds keep the case, it goes to federal juvenile court. A juvenile court proceeding in federal court takes place before the same judges and in the same courtrooms as adult court, but the procedures are different and the courtroom is sealed from the public. If there is a trial, it's held before the judge without a jury. Okay, I'm going to end there because I'll run out of time. I'll put these on the next slide. Okay, stop.